Hi, so the purpose of this video is to briefly explain what a notice of intention to discontinue workers' compensation benefits is, or for short, a NOID. And my name is Luke Smith. I'm an attorney. I do workers' compensation litigation in the state of Minnesota. And I keep in mind there's no way that I can provide actionable legal advice in a video without knowing anything about the underlying, circumstances, the reason that the NOID was filed, that type of thing. So just think of this as an overview of, in general, what a NOID is at a basic level, why one might be filed, what information can be found in the NOID, and what typically will happen if a NOID is disputed. If someone has been served with annoyed, what that tells me is that they've sustained a work-related injury. The insurance carrier has admitted primary liability for that injury, and has begun to pay that person some sort of weekly indemnity benefits for time that's being missed from work. And once an insurer starts to do that, the insurer is required by statute to file a NOID if the insurer wants to stop paying those weekly benefits. And so we'll take a quick look at that statute. Okay, so here it is right here. It's Minnesota Statute Section 176.238. Once the employer has commenced payment of benefits, the employer may not discontinue payment of compensation until it provides the employee with notice in writing of its intention to do so. The probably the more important part here is the employer is required to serve that notice on the employee and set forth a statement of facts clearly indicating the reason for the action. It has to attach copies of any medical reports or other written reports that are being relied on in support of the discontinuance. So let's take a look at the form. This is what that form looks like, with the exception that I crossed out identifying information of the case that it was from. Um, so, there's three basic reasons, I guess three classes of reasons that workers' compensation benefits are going to be discontinued. So the first and most obvious is the person receiving the benefits previously was not working or was working at a wage loss and now has begun to work at full wage, and that means the average weekly wage that was calculated by the insurer on the date of injury. So if the insurer is contending that that has happened, then this first box is going to be checked, and it's going to state the date that the insurer thinks the person has returned to work at full wage. The second reason is that the person has returned to work at a reduced wage. So if that's the contention, then the second box is going to be checked, and it's going to state the date the insurer thinks the person returned to work at a reduced wage. And then the implication is that the insurer is going to continue to pay temporary partial disability benefits. So in that scenario, it would just be that, they're saying that they're not going to pay benefits at the full rate anymore because the person has started working, and they're going to go on to pay benefits at that partial rate. That's the difference between the earnings now and the earnings on the date of injury. And then, so the third set of reasons is much more broad, and I'm not going to get into all of them, but there's a variety of other reasons that an insurer might seek to discontinue benefits. And under that statute that we just looked at, the insurer is required to clearly state the reason that benefits are being discontinued in this text box here, and attach any reports that it's relying on in support of that. And so, um, suffice it to say that just because an insurer filed one of these forms and wrote something in this text box does not mean that it's gospel. It is very, very common for employees to successfully dispute the notices of intention to discontinue in which box 3 is checked on the basis of either insufficiency of the notice or disagreement with whatever the reason is that's stated in this text box. So the employee that gets served with one of these has the right to request an administrative conference in which a judge will review this notice of intention to discontinue and will determine whether there's a reasonable basis for the discontinuance. If so, then the discontinuance stands, at least in the short term. If not, then the judge will order the insurer to reinstate the benefits that were discontinued. And those administrative conferences are informal. They're done over the phone. They come up very, very quickly. So, within a few weeks of when they're requested by the employee. However, it's important to keep in mind that in order to request that type of an administrative conference, the request has to be made within 12 days, 12 calendar days of when this form was filed with the Department of Labor and Industry. And so we'll look at that statute. And here it is right here. The employee's request must be received by the commissioner within 12 calendar days after the notice of discontinuance is received by the commissioner. And the commissioner is the Department of Labor and Industry. And so I would point out that the date that the employee receives this form in the mail is almost certainly going to be later than the date that the Department of Labor and Industry received this form, because they're transmitted to the Department of Labor and Industry electronically. So that's a tight timeline. So point being, if I were an injured worker and I received one of these forms and I thought that it might not be valid, what I would probably do is I would keep the envelope that it came in, because there's going to be a postmark on that envelope that might be important. And I would call an attorney immediately, not tomorrow, not next week, immediately. So that, that's the basics of that form. If you have questions about a notice of intention to discontinue or about any other workers' compensation issue, feel free to reach out to me. I'm always happy to answer any questions, no charge. My phone number is 952-395-1482. If you prefer, there's a contact form linked in the description for this video. You can fill that out with your name, phone number, provide some detail about the nature of your question. Click submit, and I will give you a call back within 24 hours. I hope that this has been helpful to some extent, and thanks for watching.